Hi, I'm Denise Couling of Banfield Couling Law and Mediation, and this brief video addresses a question we receive fairly frequently, and that question is, do I have to use friend of the court services for our case that involves children? The answer is a qualified no. It is possible to opt out of friend of the court services. There's special paperwork involved. It involves signing forms and paperwork where the couple indicate that they agree that they could have had the benefit of friend of the court services, but they are choosing not to use friend of the court services, that they have a high degree of confidence they can take care of this themselves. They also will have the court enter an order after finding that friend of the court services are not necessary in their case, that this case can be exempt from friend of the court services. Now, it's usually not a high standard. It's a matter of if the parties agree in most cases. And in where the parties may want to opt out of friend of the court services, but find they can't, it typically is due to one of the parties receives or the children receive public services or public benefits of some sort. So if the children are receiving health insurance through My Child, or if there's any kind of public benefit involved, then it may not be possible to opt out of the friend of the court. There are also some circumstances where even though some receipt of public benefits is involved, it is possible to opt out of the friend of the court. So please don't assume that this blanket generalization is legal advice in your specific case. But if friend of the court services are not wanted and there generally appears to be an agreement between the parties and no receipt of public benefits, then the chances are favorable, in my experience, that you will not have to be a part of the friend of the court system if you don't wish to. Also, one thing to be aware, typically, even after opting out of the friend of the court services, one of the parties will have, either party, at only one of the parties' requests, will have the right to ask to be put back in friend of the court services. So it is not a permanent bar from using friend of the court services. It is a exception for this couple for as long as both of them agree they don't need friend of the court services and their own arrangements between themselves are working. So it is possible, and it's something, this opting out of the friend of the court processes is something our firm is very experienced in. We even have a large number of our streamlined divorce clients opt out of friend of the court services. The number one issue is whether this is right for you, works for the circumstances and the agreement that you may have struck with your spouse. And opting out of the friend of the court services, by the way, cannot be imposed on the other party. It has to be a matter of mutual agreement. So I hope this is helpful in understanding a little more about how friend of the court services are available and in what types of circumstances it may be possible to opt out, and that's usually because the parties mutually agree and there's no receipt of public benefits. As with any of our videos, this is not to be legal advice in your particular case, and there always are fine points and exceptions to almost any general rule. But I hope this general overview of the friend of the court and the ability to opt in or opt out of their services has been helpful to you. Thank you very much.